Hello everyone, welcome to IASBABA's 60 days rapid revision series for Prelims 2022. This is day 49 and we take up polity topics. So some of the topics which are in news and other government initiatives we will discuss here. And before that we take up the guessworks as usual. So 41st one, which one of the following is used in preparing a natural mosquito repellent? So friends, we don't know this. We don't have this in the NCERT or any other books. So we will take our brain to our surroundings. So how a mosquito repellent works? It is like, say, for example, Odomos or Odonil, etc. So it is the stinking smell. That is the major characteristic. If someone is applying Odomos, so the whole building will be spread by the stink of that. So here, search for that grass which can probably give a stinking smell. So Congress grass, we know it is not so stinky. And then elephant grass. So this is that big grass which is grown in savanna and others. So not so stinky. Lemon grass. So lemon is something which gives a stinking smell. So we can take lemongrass as a crude guess. And then the nut grass. Friends, nut grass is something which is associated with the nuts and I don't think that it will be famous for the stinks. So we can take a crude guess here and so many students have taken this. I have analyzed so many students' papers who have given 2021 prelims and this was not that difficult a question. Then come to next. Consider the following kinds of organisms. So copepods, cyanobacteria, diatoms and foraminifera. Friends, again I will tell you like it is essential to read the NCERTs. So if you have read NCERTs, cyanobacteria and diatoms, so they are present in NCERTs. So cyanobacteria is the blue-green algae. So in the last rapid revision series also, we had discussed this and I said that this is a hotspot of UPSC and UPSC has asked a question here. And the diatoms, friends, both are the photosynthetic ones and they are the primary producers. So we'll go with 2 and 3 as the answer. But however, if you know cyanobacteria, so you will eliminate the options which doesn't have 2. So C and D will be gone and the remaining are A and B. And here consider the first one, copepods. Friends, what is a pod? So pod, tripods, copepods. So that means pod means leg. So we have arthropoda, phylum arthropoda means the jointed legs. So analyze that something which has a leg. So the God has given them the legs so that they will search their food and eat. So if they are producing their own food, so why the legs for the first place? So in that perspective, copepods cannot prepare their own food because they have got legs to search and eat the food. So if you cancel one, so B will be the answer. Then come to next, consider the following statement. Hedgehog, then marmot and pangolin. So this is again a question from abstract source. So we don't get one single source. If you have seen pangolin rolling, you would have answered this. Or if you have seen an hedgehog rolling, you would have answered. So if you leave this, no issues with that, you can leave this question. But however, as far as the preparation is concerned, so whenever you come across any species of animals, so go through the Google images and see their images. And that image memory, that can fetch you some marks. So here we will leave that question, but mind that the preparation times, you will search for images. Then come to next, with reference to the New York Declaration on Forests, which of the following statements are correct? So it was first endorsed at the United Nations Climate Summit in 2014. So here there are no extreme words. Then it endorses a global timeline to end the loss of forests. So the forest declaration, it can also be related to the loss of forests. So it is as natural as that. And it is a legally binding international declaration. Friends, this legally binding is the hotspot of UPSC. It is one of the favorite statements. And we know that not all UN conventions are legally binding. So what is the meaning of legally binding? That means if there is a legally binding convention, if any of the members, if they violate that, so other members, they can sue them in the international courts. So here again, not all conventions will be legally binding and they are not so strict. So that is why we will eliminate 3 here, and it is endorsed by government and big companies and indigenous communities. So we cannot say that governments and indigenous communities have not endorsed that. So we will take 4 as correct. So here in the options, search for such an option where it contains 4 but not 3. So it contains 4 here and not 3 only in option A. So you are done with that and cross check with the 5th statement, that is India is one of the signatories at its inception. So friends, rarely India signs some convention at the inception. At the inception means at the very launch of the convention, India went and signed that. India will never do that and no country will do that because it is insane, like without discussing, without thinking a while. So if you go and sign it, so it is not a proper diplomacy. So even in that perspective, we can crack this question. So again, it is like immaterial of whether you have read something, whether you know something, You can crack that question if you have a good guessing strategies. Then magnetite particles suspected to cause neurodegenerative problems are generated as environmental pollutants from which of the following? So here again friends, that NCERT knowledge is required. So we know that magnetite is a content of iron. So we know that hematite, magnetite, so these are the ores of iron. So here search for those options which contain iron. So the brakes of motor vehicles. Yes friends, the brake plates, if they rub against one another, so it is akin to rubbing of two iron plates and then magnetite may be released. So one should be there. And then engines of motor vehicles. So we have discussed during the leaded petrol discussion that how an engine works. It is having a container and a shaft. So in the movement of this container and shaft, so we have the rubbing here and again the magnetite might be released. So 1, 2 should be there and search for 1, 2. So A, B, C, all of them they have 1, 2. So we could eliminate only C. We will move further. Microwave stoves with the homes. So here the microwave stoves, it is mostly an electronic device. There is not much of mechanics that go on within a microwave stove. And then fourth one, the power plants. So here in the power plants, the turbines will be rotating and the turbines are iron ones. So again, 4 can be there. So here search for 1, 2 and 4 mainly. So 1, 2 and 4 we have in B and D. And again, luck is not favoring. So go for telephone lines. So we know that friends, telephone lines, they are made up of copper and rarely we have a telephone line which is made up of iron. And we have rarely a situation where the iron rubs each other. So the telephone line is a transmission line and there is no friction and rubbing motion between the wires. So we can eliminate 5 and we can walk down for 1, 2 and 4 only as the option. So it is like instead of going blindly for all of the above, I removed microwaves and the telephone lines because here we don't have any mechanical motions like rubbing and here also it is a transmission line. So there is nothing like rubbing and there is no magnetite particles that are being released. So eliminate extremities and go ahead with the option. So don't go with all of the above blindly. This lesson we have learned from the previous year's answer key. So this is how preparation goes friends. So even if you have done PhD on the magnetite particles, you can't take this question unless and until you have analyzed the previous year's questions and the UPSC official answer keys. So do that for the first if you haven't done it. Then coming to the topics, the Criminal Procedure Identification Bill. So the bill has been passed by the Parliament and some of the features of this act. So it repeals the Identification of Prisoners Act 1920. So mark this as important. Then it authorizes law enforcement agencies to collect, store and analyze physical and biological samples of the convicts and other persons. So the biometrics of the convicts and others that can be taken up and stored. And then it authorizes police to record signatures and then handwritings or other behavioral attributes referred to in the section 53 or section 53A of the Criminal Procedure Code. So it is like extraction and maintenance of the data that is being extracted from the criminals. And the resistance to or refusal to allow the taking of biometrics and other measurements under this act shall be deemed to be an offence under the section 186 of the Indian Penal Code. So that means, so if someone is taking my signature, I cannot forbid them, I cannot avoid that. And then the act empowers the National Crime Records Bureau to collect, store and preserve the records for measurements. So who will collect and store the data? The NCRB. So mark it as important. And then the act empowers a magistrate to direct any person to give a biometrics. So if a person is innocent, if he is not a criminal, but still I want to extract. So now the judicial magistrate, he can give orders to extract the biometrics of that person. So these are some of the facts. Then come to next, the sealed cover jurisprudence. So what is it? It is a practice used by the Supreme Court and lower courts for accepting information from the government agencies in sealed envelopes that can only be accessed by the judges. So it cannot be published in the media, it cannot be accessed by the witnesses and lawyers, only by the judges. Then, while a specific law does not define the doctrine of sealed cover, the Supreme Court derives its powers from the Indian Evidence Act 1872 and the Supreme Court rules. So remember here the Evidence Act and the Supreme Court's rules. And it is stated under the said rule that if the Chief Justice or the court directs certain information to be kept under sealed cover or considers it of confidential in nature, then no party would be allowed to access the contents of such information except the Chief Justice himself orders that the opposite party be allowed to access it. So unless and until the Chief Justice himself orders to give the access, so no one has the access to it. Friends, this has been in news for last 2 to 3 months. So again, that becomes important. So we had a question in UPSC 2021 prelims, that is the committed judiciary. So the word committed is not present in the constitution. It is informally used in the bureaucratic parlance. So such words and concepts which are used in bureaucracy and judiciary, so they have to be studied. So that is why I have brought it, the sealed cover jurisprudence. Then come to next, it also mentions that the information can be kept confidential if its publication is not considered to be in the interest of the public. So if it is against the public interest, even then the sealed cover jurisprudence can be taken up. Then the Evidence Act protects the unpublished official documents relating to the affairs of the state. So a brief description on the Evidence Act, and then the same Evidence Act also forbids any public officer from disclosing any government information. So here remember the sealed cover jurisprudence, and also remember the Supreme Court rules and the Evidence Act and the meaning of this word. So that is more than sufficient for us. And then surrogacy and the ART. So what is the actual difference? So surrogacy regulation bill relates to an infertility treatment where a third person or a woman is the surrogate mother. So surrogacy crudely is donating the womb for the baby of others. But however, in ART, that is in artificial reproductive treatments, treatments can be availed by the commissioning couple themselves, and it is not always necessary that a third person is involved. So ART is nothing but the in vitro fertilization, then the test tube babies, so all those things. So here donating of the womb or the selling of the womb will not come into picture. Then surrogacy is allowed for only Indian married couples. So as per the Surrogacy Act, we know that only for Indian couples, foreigners they can't do surrogacy here. And we also know that only altruistic surrogacy is allowed in India. So the commercial surrogacy is not allowed as per the surrogacy bill. Then the ART procedures are open to married couples and then live-in partners and single women and also foreigners. So unlike surrogacy, ART is available for foreigners and also for the people with the live-in relationships. Then come to more facts. A 2015 notification prohibits commissioning of surrogacy in India either by foreigners or by PIO or OCI card holders. But NRIs holding Indian citizenship can avail surrogacy. So as per Indian rules, it is the OCI and PIO card holders are also not allowed to carry on surrogacy in India. Only the NRIs who are holding the citizenship of India can do that. Then foreigners can visit India under the medical tourism to avail ART services. So ART is available for foreigners. Then under the surrogacy bill, there will be a national surrogacy board that will be involved in policy making, and it acts as a supervisory body, and state boards, so that will act as executive bodies. So state boards, they will regulate what surrogacy is required or not, and the national board, so that will look into whether the state boards are working properly or not, and it will set the broader policies. Then the ART bill, so that provides for a national board which is different from the national surrogacy board, and this national board functions like a civil court under the civil procedure code. So here remember the crude difference between the concept of surrogacy and ART and some of the rules and regulations which are different for the surrogacy and ART. Then come to next, the Waqf. So Waqf is a property given in the name of God for religion and charitable purposes. And in legal terms, it is a permanent dedication by a person professing Islam of any movable or immovable property for any purpose recognized by the Muslim law as pious, religious or charitable. So it is a donation given by a person for the religious charity. Then a Waqf can be formed through a deed or instrument or a property, and it can be used by the Waqf board for a long period of time. So basically, like once if you donate, so Waqf can use it for any purposes, and the proceeds are typically used to finance educational institutions and to build the graveyards and mosques and to build the shelter homes. And then the Waqf properties in India are governed by the Waqf Act 1995. Then the Waqf board is a juristic person with the power to acquire and hold property and to transfer such properties. So acquisition, holding and utilization and transfer of properties of these Waqf properties is done by the Waqf board. Then the Waqf can sue and be sued in a court as it is recognized as the legal entity or a juristic person. Then the Waqf board has powers under the law to administer, recover, then transfer or sell or give it as a gift, and then mortgage or lease any Waqf properties. So Waqf board is the sole authority on the Waqf properties, and it is a statutory body. Then come to next, the Article 311. So in a first such order, a J&K government teacher who in the police records is a Tehreek-e-Hariyat supporter who was terminated from his service without holding any enquiry. So it is in the interest of the security of the state. So one teacher was found that he was a member of a suspicious organization and he was removed from the job without any enquiry. And here, the Article 311 of the Constitution of India deals with the dismissal, removal, or reduction in the rank of persons employed in civil capacities under the union or a state after holding enquiry against them. So, Article 311 specifies that enquiry should be held, but why he was terminated without any enquiries? So, we will see further. So, under the Class 1 of Article 311, a civil servant can only be removed from his office or services by the authority who has appointed him, or some other person who has the same authority, but in any case, not the authority who is subordinate. So it is like if President appoints an All India Service Officer, only President can remove him, so no other person who is subordinate to the rank of the President of India can remove him. So all these you know. And then under the Class 2 of the same article, civil servants are provided with the right of being heard. But however, all government servants cannot avail of these protections, that is, all need not be heard. So in what all cases this right to be heard can be evaded. So it is like if the civil servant has been found guilty of a criminal offense, or if a person has gone rogue, that means he has joined any terrorist organizations, or if it is not feasible to hear such persons. So under these three conditions, the right to hear, so that can be evaded. Then in Purushottam Lal Dhingra case, the Supreme Court held that the protection provided under the Article 311 to the civil servants includes permanently employed civil servants as well as temporarily employed civil servants. So the right to be heard applies for temporary employees as well. So this is a brief account on Article 311. Then come to next, the Central Consumer Protection Authority. So it is constituted under the Consumer Protection Act 2019. So again, it is a statutory body. Then the CCPA will have the powers to inquire or investigate into matters relating to violation of the consumer rights or unfair trade practices. So as natural, not so big a fact. Then it can take suo motu cognizance or inquire on a complaint received or on a direction from the central government. So in all these ways, they can take up a complaint and they can air the grievance. Then the Consumer Protection Act 2019. So here CCPA will be empowered to conduct investigations into violations of consumer rights, and then it can order recall of unsafe goods and services, and it can also order the discontinuance of the unfair trade practices and misleading advertisements. And here an alternate dispute resolution mechanism of mediation has been provided in the new act. So mark this as important. So Consumer Protection Act, so that has alternate dispute resolution as well. Then it brings within its scope the product manufacturer, then the product service provider and the product seller for any claim for compensation. So all stakeholders are involved while awarding compensation. Then the court may, in case of first conviction, suspend any license issued to the person for a period of up to 2 years. And in case of second or subsequent conviction, the license can be cancelled permanently. So initially 2 years, and if the mistake is being repeated, so permanent cancellation of the license. So this is all about the CCPA. Then come to next, the Article 243U of the Constitution. So friends, this basically deals with the tenure of municipality. So here, every municipality, unless sooner dissolved under any law for the timing in force, shall continue for 5 years from the date appointed for the first meeting. So that is, if there are no law which is terminating the municipality, so they will continue for 5 years. And the municipality will no longer function provided that a municipality shall be given a reasonable opportunity of being heard before its dissolution. So here, say for example, if a municipality is about to be dissolved, so if a reasonable opportunity is being given to hear why it should not be dissolved, then after that, so the municipality will no longer function, it will be dissolved. And then no amendment of any law for the time being in force shall have the effect of causing dissolution of a municipality at any level which is functioning immediately before such amendment. So that means, so currently no law should be terminating. So in other words, retrospective termination is not allowed. That is, you cannot amend a law and then terminate. Then come to next, an election to constitute a municipality shall be completed before the expiry of its duration specified in the clause 1. That is, before 5 years and before the expiration of a period of 6 months from the date of its dissolution. That is, in case of dissolution, before 6 months, election should be there. And provided that where the remainder of the period is less than 6 months, it shall not be necessary to hold any election under this clause for constituting the municipality for such period. Say for example, a municipality is being surviving for 4 years and 8 months. So for completing 5 years, it has only some 4 months left. So in that duration, the elections need not be held again. So we can hold it after 4 months along with the other municipalities. Then a municipality constituted upon dissolution of a municipality before the expiration of its duration shall continue only for the remainder of the period. So here say for example, every 5 years the election for municipalities will occur, and in the middle of the term, that is after 2 years, one municipality got dissolved. So here if the by-election occurs, so only for the next 3 years the new municipality will function. So this clause is being added to sync the elections of municipalities. Say for example friends, there are n number of municipalities in one state, and here if you give 5-year full term, so the elections will go unsync, and in that case we can reach a situation where election will be held every month or say every week for that matter. So to avoid that, so only for the remaining term the municipality will survive, and the general election for municipalities will occur only after 5 years, and the new municipality will come and that will survive for the next 5 years. So this one clause is different compared to the state legislature and parliament where the 5-year term is fixed. So remember this clause carefully. Then come to next, OBC quota and the triple test. So here Supreme Court has directed Maharashtra government to adhere to the triple test for giving OBC reservations. And the triple test requirement is a 3-pronged criteria set up by the top court to mandate the OBC reservation. And here it requires the state to set up a commission to conduct a rigorous empirical inquiry into the nature and implication of the backwardness of the local bodies. So first criteria, to set up a commission to inquire into the backwardness. Then to specify the proportion of reservation required to be provisioned in light of the recommendations of the commission. So what proportion of reservation are you giving? Then in any case, such reservation shall not exceed an aggregate of 50%. So if we fulfill all these three, the triple test quota will be completed and the state can go ahead with the reservation. Then come to next, official language and other related articles. So here we have Article 343 of the Indian Constitution that states that official language of the Union shall be in Hindi, that too in the Devanagari script. So here mind the official language, not the national language. Then according to Article 345, the legislature of a state may adopt any one or more of the state's official languages, including Hindi, like the languages or languages to be used for all or some of the state's official purposes. So here the states have the freedom to set up their own official languages, and Hindi can also be one of the official languages. Then the Official Languages Act 1963 provides that English should be the communication language between the Union and the non-Hindi states. So no states should communicate in Hindi for a non-Hindi states. So a matter of bonhomie is being depicted under this clause. And then Article 344 clause 1 and 351 of the Constitution provide that there is an 8th schedule and there are 22 languages in that schedule. So these are some of the articles in the Constitution related to the official language. Then the language of Supreme Court and the High Court. So here the Article 341 clause 1 subclause A states that unless the Parliament by law provides otherwise, all proceedings before the Supreme Court and in every High Court shall be conducted in English. So Parliament, remember, and also that only in English, remember. And Article 348 clause 2 provides that notwithstanding the provisions of the previous article, the governor of a state may, with the previous consent of President, authorize the use of Hindi or any other languages used for any official purposes in proceedings in the High Court. So as far as High Court is concerned, the governor, with the consent of President, so he can use Hindi or any other languages. Then, however, the judgments should be delivered in English only in the High Courts. So only for proceedings, other language can be used, and for the judgment, English only. So remember, for Supreme Court, both in proceedings and judgment, English alone. In the High Court, proceedings can be in the regional language and judgment in the English alone. Then the language in the subordinate courts. So section 272 of the Code of Criminal Procedure states that the state government shall determine the language of all courts other than the High Courts. So here mark state government as important. Then the state government has the power to declare any regional language as an alternative for the proceedings of the court. But however, judgments, orders and decrees may be passed in the magistrate in English. And then the recording of evidence shall be done in the prevailing language of the state. And then in case of a pleader being unacquainted with English, a translation into the language of the court shall be supplied to him on his request, and the court shall bear such costs. So the translated judgment shall be given by the court from its own cost. So remember friends, this happens only in the subordinate courts, so it need not happen with the Supreme Court and the High Court. Then come to next, the Article 344. So that is Commission and Committee of Parliament on Official Language. So here the President shall, at the expiration of 5 years from the commencement of this Constitution, and thereafter at the expiration of every 10 years, so he shall constitute a language commission. So here it is like from the commencement of Constitution within 5 years, and from the expiry of every committee, so 10 years. So he will establish a committee, and the members should represent the different languages specified in the 8th schedule as President may appoint, and the order shall define the procedure to be followed by the Commission. So the order of the President will specify what procedure the Commission will follow, and the Commission will have equal representation from all the scheduled languages. And then the duties of the Commission to look into the progressive use of Hindi language for the official purpose of the Union, and then restriction on the use of English language for all or any of the official purpose of the Union, and then the language to be used for all or any purpose mentioned in Article 348. So that is the courts and the form of numerals to be used for any purpose of the Union and any other matters. So friends, here remember who sets up the committee and the duration within which he will set up, and the representation of the Commission and the functions of that. Then come to next, the reasonable accommodation. So here Karnataka court rejected the argument in support of allowing Muslim girls to wear headscarves, so the hijab case, and in this the judgment was based on the principle of the reasonable accommodation. So it is like the general principle of reasonable accommodation is unless some undue hardship is caused, so such accommodation should be allowed. So if there is no hardship, so any person's activity should be welcomed and allowed, and it expresses the positive obligation of the state and also the private parties to give additional support to the persons with disabilities in order to facilitate their full and effective participation. So basically this reasonable accommodation is with respect to the persons with disabilities. That is in India, the Rights of Persons with Disabilities Act 2016. So that will define the term reasonable accommodation. So this is defined as the necessary and appropriate modification or adjustment without imposing any disproportionate or undue burden in a particular case to ensure that the persons with disabilities enjoy or exercise rights equally with others. So in crude it is like unless and until there is any reasonable hardship, we should encourage the persons with disabilities to enjoy their way of life. And this was applied to the hijab case here. So for us, remember the reasonable accommodation, and also it is present in the Rights of Persons with Disabilities Act. So that is more than sufficient for us. And then the proportionality principle. So here again, Supreme Court asked the government and private agencies to apply the proportionality principle while applying COVID vaccine related restrictions. And here the court invoked Puttaswamy verdict of 2017 to say that a person's right to bodily integrity and personal autonomy under Article 21 includes the right to refuse vaccination. So mark this judgment as important. And here we look into Puttaswamy judgment case so that we will understand this proportionality principle better. So here the court held that privacy is a natural right that inheres in all natural persons and is an intrinsic part of life and liberty under Article 21. So we know this. So this right to life may be restricted only by the state's such action that passes each of these three tests. So what are those three tests? First one, such state action must have a legislative mandate. So such actions should be passed in the legislature. And second, it must be pursuing a legitimate state purpose. And the third, it must be proportionate. That is, such state action, both in its nature and extent, must be necessary in democratic society, and the action ought to be the least intrusive of available alternatives to accomplish the ends. So that means if there are no alternatives available to accomplish that end, so we can go up with this action. Else we have to go with the alternatives, not with this per se. So here we don't have any other choice but to vaccinate the people. Only then we can go and vaccinate, else we can go ahead with the other ones. So this is all about proportionality principle. Then come to next, the section 436A of the Criminal Procedure Code. So friends, here the Criminal Procedure Code 436A says that if a person is under trial and if he has already undergone half of the duration of punishment that he might probably get if he is actually convicted, so he shall be released. Say for example, if a person is convicted under the murder case, so he will be getting 14 years of imprisonment. So this 14 years is the probable years of imprisonment he will be getting. And before the conviction, he has already spent 7 years in jail. So that means he can be released. And here, this is not applicable to the capital punishment. But however, this pre-release shall not happen if the public prosecutor, in his opinion, he says that the continued detention is necessary. So if there is a suspicion that he will go out and he will tamper evidence or he will do any of such mischiefs, so then this 436A will not apply and he or she shall not be released. And for this again we have a counter clause. So it is like no person shall in any case be detained during the period of investigation, enquiry or trial more than the maximum period of imprisonment provided for the said offence. Say for example, we will go with the same 14 years imprisonment. So if a person probably is getting 14 years of imprisonment and he has completed all the 14 years instead of 7 years, so even if there are chances of him tampering evidence, so he shall be released. So here the tampering of evidence will not come into picture because the person has already experienced 14 years of imprisonment. So that means he has indirectly accepted the crime and he has undergone the full punishment. So there are no chances of him keeping in the prison even after 14 years. And in the computation of the period of detention under this section, the delay done by the accused will not be considered. So only the delay done by the court's part will be considered. So if the accused himself, if he delays, so that will not be considered. Say for example, if you go with the same case of this 14 years, so a person has spent 6 years in jail and 1 year he has delayed in the investigation and others. So he might be absconding and he was not available for 1 year. So this 1 year will not be considered. So only the 6 years will be considered and he will have to wait for 1 more year so that he will complete his 7 year and he will be released. So his mistakes, so it is not considered. So all these are the legal clauses. So break them into small pieces and try to understand them. So you need not by heart all these things. Then the National Commission for Minorities. So here the National Commission for Minorities was set up under the National Commission for Minorities Act. So hence it is a statutory body. Then this monitors the working of the safeguards for minorities provided in the Constitution and in the laws enacted by the Parliament. So but obvious, not so great a fact. Then it ensures that Prime Minister's 15-point program for the welfare of minorities will be implemented. So mark this as important, although it is an old scheme. Then it investigates matter of communal conflicts and riots. So but obvious, then it investigates matters of communal conflicts and riots. And then composition of the commission. So NCM consists of a chairperson, a vice chairperson and 5 members, and all of them shall be from amongst the minority communities. So mark this all as important. It is not an extreme word. So it is factually correct. Then each member holds office for a period of 3 years from the date of assumption of office. So they have 3 years of tenure. So mark it as important. Then the background of National Commission for Minorities. The Minorities Commission was envisaged in the Ministry of Home Affairs resolution in 1978. So with the resolution as an executive body, it was set up for the first time in the Home Ministry. Then in 1984, it was placed under the newly created Ministry of Welfare. So it was shifted to Ministry of Welfare. Then in 1992, with the enactment of National Commission for Minorities Act, it became a statutory body. And in 1993, 5 religious communities, that is Muslims, Christians, Sikhs, Buddhists and Zoroastrians were notified as minority communities. And in 2014, Jains were also notified as minorities. Then, at present, National Commission for Minorities function under the Ministry of Minorities Affairs. So here, friends, in the last year we got the question on DARPG. So on that context, this is also worth remembering. Then come to the last part. Friends, as and when we study polity and law, we should also ensure that every citizen in India should have awareness regarding minimum legal clauses. So minimum legal clauses like what are the clauses for the violence, what are the clauses for hiring a house, and what are the labor rights. So all these minimum knowledge should be there so that he can air his grievances properly and he can lead a peaceful life. So before we teach them the astrophysics or the economics or anything complex, so minimum law should be there. So that is the one which will give them a peaceful and a meaningful life. So if not now, at least in the future, we will all make sure that the minimum law is taught from the schools, colleges and also in universities. And by this we can begin a new India with the citizens living with utmost peace and dignity. So all the very best from my side.